Hey there, Faithful Politics family. Will Wright here. I've got something special to share with you. Something we've been working on for the past year. It's an audio narrative series called Heavenly Homeland that dives deep into the topic of Christian nationalism, which is something that's been making the headlines and stirring lots of conversations in homes, churches, and political circles. I'll be back in a bit to tell you more about the details, but I wanted to at least pique your interest if I could. So in the meantime, hope you're doing amazing and enjoy the rest of the show.
Assuming one could get an actual decision, should Congress be responsible, and should Congress's action then guide what states do? So assume that Congress gets together and says, you know what, we actually think that January 6th was an insurrection. Should states be required to take that as the truth and merely ask themselves whether a candidate, even for a state office, was involved in January 6th in a way that means that they engaged in insurrection? Or should the state be able to just decide on its own, because it's talking about a pure state matter, should they be able to decide on their own regardless of what Congress decides?
Hey, welcome back, Faithful Politics listeners and viewers. If you're watching our YouTube channel, I'm your political host, Will Wright, and your faithful host, Pastor Josh Bertram, is out today. But we have with us, returning to us, actually, Professor Henry L. Chambers, Jr., who teaches and writes in the area of constitutional law, criminal law, and religion. And if you remember, we had him on to talk about when Trump was going to be banned from the Colorado ballot. And now he's returned to give us his thoughts about the recent Supreme Court case that just occurred. So, and welcome back, Henry.
Good to see you, Will. Good to see you. Good to talk with you.
Yeah, good to talk. You know, I was thinking recently, especially for like folks that in the world of academia, like do you utilize a lot of these cases like in your curriculum? Because I feel like there's just a mountain of curriculum and stuff you could review in your classes.
Yeah, it's a great question. There are so many things that we can think about and we can use that we just have to make choices. And it's the making of the choices that's the key. So when I think about this case or the oral argument, if I were teaching the basic constitutional law course right now, we would talk about what the justices are thinking about in oral argument, even before they issue an opinion. Because we're not sure what the opinion is going to be, but given the conversation that occurred, we have a sense of what's what. I do the same thing if I were teaching my voting rights course this semester. I had a good chance to talk with a colleague of mine in front of a group of students last week about what was going on, and pretty interesting to hear what folks asked. It was the day before the oral argument, so it was interesting. But talking through those issues, very important for law students, very important for non-law folks to also talk about those issues.
Got it. Yeah, I didn't go to school for law or constitutional law. I actually went to school for occupational safety, of all things. It's one of those, like, doing this podcast has sort of reinvigorated my interest in a lot of like the civic classes I had decades ago. And it's like I'd love to just one day just go into one of the classes of some of our guests that we've had on just to hear them speak, because I'm just fascinated by it. Like the students that you teach, because you teach at a law school, so I'm assuming that most of the students there actually want to be there. Like, this isn't just like an elective or something.
You know, that's a real interesting question. They want to be here, but part of the question for some law students is, why do they want to be here? That is, do they want to be here because this is where they go before becoming lawyers, or do they really want to think about the law? And we have a lot of folks who are happy to be here and recognize that they need to learn things before they can practice. But you also have some people who say, I'm not sure that I would want to be in this situation if it weren't functionally required in order to become a lawyer. And certainly different parts of the law can excite people in different ways. The constitutional law question, though, for me is one where I say, everybody, whether in law school or out of law school, has got to think about civics, has got to think about constitutional law and what it means, because it's what tells us what the government does or what it's appropriate for the government to do. So I would certainly love to have you swing into one of my voting rights courses, and we can talk in general about what goes on, what the Constitution says in terms of figuring out how do we want the law to work for us, we the people.
Got it. Yeah, that's really cool. So talking about this case in particular, and before I kind of get into the substance of the actual arguments, can you kind of walk us through of like the procedural steps of how like a case in Colorado actually gets to the Supreme Court? Like we've actually talked about quite a few Supreme Court cases like on this pod, but I don't think we've ever really talked about like how does a case from Colorado get to the Supreme Court, and how do the justices decide that's what they want to hear?
Right. Really good question. Most lawsuits, if not all lawsuits, start with somebody saying, I just don't like what's going on. And I'm going to go to a court to figure out, or to have the court figure out whether I should get some relief. So in this situation, you have the government of Colorado, state of Colorado, that has to figure out who should go on a primary ballot. And as of a certain day, the ballot has to be printed. So before that, they have to figure out who's going to go on the ballot. Apparently, a number of voters, Republican voters, actually in Colorado, complained to the state that Donald Trump shouldn't be on the ballot because he was not qualified for the office that he was seeking. So they ask the secretary, I think they asked the Secretary of State, who was taking care of the ballots, and said, well, he shouldn't be on the ballot. And that then triggers a problem. Colorado says, okay, what do we do with this? The Secretary of State and the Republican Party and Donald Trump end up in a trial together. And after the trial, the Colorado State Court says, yeah, he's not qualified. And that goes through the Colorado Supreme Court as well. Well, now the question becomes, is there a constitutional issue that the Colorado State Court has decided? If so, then the matter can be appealed to the U.S. Supreme Court, and the U.S. Supreme Court then figures out what to do with the situation. And in this circumstance, the 14th Amendment of the Constitution and a number of other issues were triggered. So it becomes an issue that the Supreme Court says, yes, this is an issue that we should resolve. This is one that we should take a look at because it implicates federal issues and constitutional issues.
Got it. And the Supreme Court, like, I mean, I'd imagine their calendar is pretty booked, and this case sort of came out of left field, so to speak. So, I mean, like, how do they decide that, yeah, we want to rush this one, versus, another relevant water rights case or something that they would argue?
Right. Well, they set their own calendar and they make their own decisions. So they have the latitude to hear things on an emergency basis or no. And that decision in and of itself is an important one. If it's a situation where they say, look, they're all important, but they're not pressing, then they can say, well, we'll hold it over for the next, we'll put it in line so that we hear it when we hear it. Or they can hear a case that jumps it to the front of the line, like the immunity case. It's also coming through that the D.C. Circuit decided last week or 2 weeks ago that the Supreme Court is saying, okay, now that's been appealed, let's decide whether we're going to take it on. So they can set their calendar based on whether they think a particular problem absolutely has to be resolved right now. And this is one, it's fair to say, that a ballot issue that deals with even the general election, although this one really had to do with the primary, that's been resolved. But one that has to deal with the general election, you got to start cranking on that one. You can't just stick it into the normal course because then it won't get decided before it needs to be decided for the 2024 election.
Got it. So with the oral arguments, what are some of your big picture takeaways, and then we'll drill down into maybe some of the other more detailed issues.
Sure. Let me. Well, I'll take one broad comment, one comment that's in the weeds, but in the weeds is still, I think, a fascinating question. The broad comment is that the court seemed willing to functionally ignore the notion that the 14th Amendment, Section 3 exists. Now, some people would say, oh, you're being unfair. Fine. Well, let me explain what I mean. What I mean is, it's clear that the language is there, but the way they talked about it, it was as though there's no remedy that they are willing to provide. So they said, well, we recognize that someone who has engaged in insurrection and who has not had that disability removed by Congress is in fact not able to serve. But then they sort of throw their hands up and say, but what are you going to do? and that's the piece where you look at it and say, well, hold on a second. The 14th Amendment is there. The language is relatively clear. Well, it's very clear regarding if you qualify as someone who cannot serve. If you are someone who has been disqualified, then you cannot serve. But the notion that there's not really much that we can do about it is fascinating. So that's one, and we can talk about that a little bit more. Here's the piece that's a little bit more in the weeds, but is I think quite relevant. The court continued to talk about national elections. And that's fascinating because there's no such thing as a national election. We have federal elections, or more precisely, we have state elections for federal offices. Now, I realize that people would say, okay, what's the difference? And isn't the presidential race a national race? The answer is, no, it's not. A national race would be one that involved a national popular vote where a state in one jurisdiction is counted the same as a state in another jurisdiction. That's not what we have. We have what amounts to 51 separate state elections. We then amalgamate the election results through the Electoral College, but we don't amalgamate the individual votes. So I understand what they mean when they say, well, it's a national election because election returns from different states will play into who's elected, but it's not really a national election. It's a federal election where we take the results from individual states and we put them together through the Electoral College. That's just a very, very different thing. And one of the reasons why I say it's in the weeds, but it's very important, is they also talk about national officials when they should be talking about federal officials. And they talk about folks like U.S. senators and suggest, well, that's a national office. No, it's not. It's not. We elect senators by state.
Yeah.
So there's a pretty good, and we only elect them by state after the 17th Amendment, which wasn't passed until 1913. So when the 14th Amendment was passed, they were still selecting U.S. senators by the legislature. So while the U.S. senator serves in a national body, that person comes from a state and is selected from the state. So to my mind, it's very important to distinguish between people who serve as U.S. government officers and people who serve as essentially delegates to the federal government from individual states. And that's a distinction that they simply did not make. And I think it's ironic because you hear a lot of talking about, well, states' rights this, states' rights that. The whole concept of states' rights comes from the notion that states themselves have certain powers and certain abilities. Well, one of those abilities that is at the state-based level is selecting U.S. senators and U.S. representatives. But the court just kept throwing on the concept of, well, it's a national election. No, it's not. And they should know better, but I think that they have gotten into the into the nomenclature of talking about national this, national that, at least in this case. Mm-hmm. But oh goodness, if you want to talk about things like the Affordable Care Act, they're talking about state prerogatives as much as possible. So I think it's very, very, very interesting to sort of walk through the way the court talks about these particular issues.
Yeah, and you mentioned something that I heard quite a bit in the oral arguments about Congress removing disabilities. Can you expand on that?
Yeah. The notion is that if you look at the 14th Amendment as a whole, and I'll give you one more surprising piece of the puzzle, the 14th Amendment has 5 different sections. Right. So Section 3, of course, is the third section. Fine. Section 2 also deals with voting. There's an irony, and one of the ironies is that nobody mentioned Section 2 and whether we should read Section 3 at the same time as Section 2. I mean, they were passed in the same amendment, so one might think that arguments related to Section 2 might also relate to Section 3, but nobody talked about it. It was as though Section 2 does not exist. Well, you get to Section 5, and Section 5 says Congress can enforce the 14th Amendment as they see, essentially as they see fit or as appropriate. Okay, fine. So one of the arguments that was being made is, well, if there's no obvious solution to the problem, and there's no obvious way to resolve the issue, then we should really let Congress figure out how to deal with the issue, at least where it involves, scare quotes, national offices. Mm-hmm. When it involves state offices, well, maybe we'll let state officials figure that out. But when it comes to national offices, Congress should deal with the issue. Well, okay, you can say that, but to the extent that states have to figure out who's on their ballot based on who is qualified and based on state law, it's an odd thing to say Congress should be the one to figure this out. The court pointed to a couple of precedents that may suggest that Congress should be involved in this process because you don't want states doing these issues on their own. But I don't think that the precedents are clear on those issues. Instead, I think it's the court saying, as some other folks have argued, we want an exit ramp. We know what we should do, but we want an exit ramp so that we don't have to decide the issue. And one of them is saying, well, really, Congress should make the determination here. Interesting, because Section 3 actually contains, at the end of Section 3, not Section 5, but Section 3, says that Congress can remove the disqualification disability by a 2/3 vote. So arguably, Section 3 says if you're disqualified, you're disqualified, regardless of what Congress says, but Congress can remove that disability by a 2/3 vote. So arguably, Congress's responsibility is already embedded in Section 3, but clearly the Supreme Court's position is we don't want to deal with this. We just don't want to deal with this, so let's not deal with it.
Is that sort of like the equivalent of like a congressional pardon or something?
There's a real good argument that it is. That is, take the folks who were involved in what clearly amounts to an insurrectional rebellion, the Civil War. And the notion is, well, those people, essentially Confederates and similar folks, at least Confederates who had taken an oath to support the Constitution before they then engaged in insurrection. So, but let's take somebody who clearly had done that. Let's take, say, Robert E. Lee. Right. Robert E. Lee arguably is immediately unable to run for president or any of the other offices that are mentioned in Section 3 of the 14th Amendment. If we deem that to be simply the case because we read Section 3 of the 14th Amendment, then without any additional concern or any additional legislation, Robert E. Lee can't serve. Mm-hmm. Well, the notion is, well, because there may be a difference of opinion regarding service, maybe we should require Congress to first say who can't serve. And then once it's clear who can't serve, then Congress can say by 2/3 vote, oh, you can. So yeah, that is the way we would think of that 2/3 language as being kind of like a pardon, because yes, it removes a disability that the Constitution clearly sets forth on a particular individual. So we can kind of understand that idea that maybe that is the pardon. I think the court's position is fine. We understand the pardon piece, but we still think Congress should, in the first instance, still say who's disqualified from serving. And that's an interesting way of thinking about language that's relatively clear.
So Justice Kavanaugh mentioned something about like an 1869 decision on the Griffin's case. Is that connected somehow?
It is. Here's the messy part of Griffin's case and the problem with facts. We sometimes say bad facts make bad law, and Griffin's case may be one of those situations. The problem you ran into in Griffin's case is you had a defendant, a black defendant who had been convicted. The problem you ran into was that the judge in the case was someone who should have been disqualified under Section 3 of the 14th Amendment. So the defendant said, well, hey, if the judge should have been disqualified, then the case should essentially be reversed because he didn't have the authority to serve. He shouldn't have been in office. And Salmon Chase, who was sitting as a circuit court judge at that time in that case, said, no, we're not going to say that every decision made by somebody who should not have been serving or who was immediately disqualified when the 14th Amendment was passed, we're not going to say that every judgment made by that person moving forward is void. Well, we can kind of understand why the court would say that, why Judge Salmon would say that. It's like, look, that would just throw everything into disarray. In a situation like that, we ought to rely on Congress to figure out when that person gets removed and how they get removed. Well, you can understand why in that particular situation, we might say, yeah, we're not going to look at the 14th Amendment and say that person was disqualified as of the date the 14th Amendment was passed. Instead, we're going to wait. What Justice Kavanaugh essentially said is, well, given that, shouldn't that be the case in all circumstances? And doesn't that mean that Congress should be the one who always determines how the 14th Amendment, Section 3, gets applied? And a reasonable response is, come on, man. It's one thing if you're in office. It's another thing if you're running for office. And if you're running for office, surely it makes sense for a state to be able to simply say, no, you are not qualified for office. Therefore, you can't run and you can't get elected. That is a completely different factual situation than, hey, I'm already in office. Now you're trying to pull me out. And not only are you trying to pull me out, but you're trying to say that all the decisions that I made as of the moment the 14th Amendment was passed are void. That might be a step too far, and we understand that. But when Justice Kavanaugh then says, let's apply that to other situations, we have to say, oh, okay, you really don't want to get involved in this. It's not that it's too hard, it's just too messy. Okay, it's too messy. You don't want to get involved. And justices on both sides of the historical divide, both sides of the divide, seem to be in that situation. Justice Kagan doesn't seem to want to get involved. Justice Jackson doesn't really seem to want to get involved, although at least Justice Jackson said, well, let me make an argument. I'm not thrilled with her argument. They're all really, really smart. She's really, really smart. I think her argument is very problematic, but it is what it is. I think it's her way of trying to find another off-ramp, but it is what it is.
I guess why do you think that there was some, I don't know, trepidation to really lean in hard on this case?
Stay with us. We'll be right back.
Hey, it's Will again to tell you about Heavenly Homeland, which is an ambitious project that draws from the past 4 years of our podcast to tell the story about Christian nationalism in 5 informative episodes. The episodes in the Heavenly Homeland series will address the belief that America was founded as a Christian nation, the separation of church and state, using the Bible as a tool of oppression, why evangelicals love Trump, and finally, an episode showing why not all Christians are Christian nationalists. We have over 24 experts from the world of academia, theology, constitutional law, mental health professionals, and so many more. The first episode airs on March 3rd, which happens to be the date Lemon v. Kurtzman was heard at the Supreme Court. And if you're wondering what that is, well, wait till episode 2. You'll learn all about it. The remaining episodes are going to air every Saturday after that. This documentary is an invitation to explore, to understand, and to engage in a conversation that's more important now than ever. Whether you're a devout follower, a concerned citizen, or somewhere in between, there's something in this story for you. So if you haven't already, go ahead and smash that subscribe button on your podcast platform. It's right there. Just press it so you can make sure that you don't miss it when it comes out. Let's embark on this journey together, equipped with knowledge, empathy, and a willingness to listen to the myriad voices that make up this great nation of ours. Stay tuned, stay informed, and as always, make sure to keep your conversations not right, not left, but up. And let's keep bridging the gap between faith and politics with an open heart and an open mind. Thanks for listening, and enjoy the rest of the show.
Yeah, I think a big part of the problem is that it is very messy and people are worried about partisanship. That is, you had a couple of, I think Chief Justice Roberts at one point said, well, any state could decide that somebody had been involved in an insurrection and at that point you can start disqualifying people all over the place. And okay, yes. Different states can do wacky things. Whether or not that is a reason to not enforce the Constitution is a different story. I assume that they are being honest, that that's what their concern is. I assume that they are worried that a state may decide that Joe Biden somehow, some way, somewhere has engaged in insurrection. But at some level, that would boil down to trusting state courts and state governments to do the right thing. Now, if they want to come out and say, we can't trust state governments and state courts to do the right thing, it would be in some ways refreshing for them to say that. But in other contexts, they don't say that at all. When it comes, for example, to death penalty cases, they don't go around and say, oh, well, we just don't trust state courts. No, they try to bend over backward to trust state courts. So it's an interesting concept that in this situation, they say, we can't trust state courts and we can't fix the problem as opposed to others. And they never answered the question, well, what do we do with the notion that Colorado, in all fairness, had a trial and did the kinds of things that you would expect a state to do to figure out whether or not President Trump engaged in insurrection, and whether you like the conclusion they reached or not, they did it in the way that we have historically expected states to do things, right? In the same way that when they have a trial, I don't think Colorado has the death penalty, but in a trial, in a criminal trial, if someone's found guilty of something, the court doesn't just look up and say, well, you really can't trust that verdict. They say, we should trust it until there is great reason to believe that it's not trustworthy. So very interesting in terms of how they think about who to trust, how to trust, when to trust, and what they believe are the real concerns with courts getting outside of what they think is appropriate adjudication. Just real interesting to hear that that skepticism in the court.
Outside of Griffin, has the Supreme Court heard a case similar to this that you're aware of?
I'm not sure that they've heard one that's just like this one. There was a very small number in the early 1870s. The Congress passed an Amnesty Act, which essentially made most of the folks involved available to run for office. So there's a very, very small, even number of instances that were possible for the Supreme Court to hear a case like this. Now, lower courts have heard cases along these lines and have come out in some circumstances and said, yeah, you're disqualified from office. But I don't think the Supreme Court has heard a specific case along these lines. Like I say, one of the reasons is because of that Amnesty Act, one, and number two, you just haven't had people engage in what even comes close to insurrection or rebellion at this level. And that's the other piece of the puzzle is, yeah, the court hasn't done anything in part because you haven't had people act the way folks acted on January 6th. And I'm even leaving aside at this point whether the court believes that what happened on January 6th was an insurrection or rebellion. That's another loaded question that they did not really seem to want to answer at all.
Yeah. It was kind of it. It did seem like they were very precedent averse.
Yeah.
I mean, all the justices, the liberal justices and the conservative justices, which struck me as kind of bizarre. But I'm curious, depending on which way that they rule. And I'll wait to the end to get your thoughts on how you think they'll rule. But depending on how they rule, what would that mean? I guess moving forward with other cases of this magnitude. People will cite the Supreme Court, the whatever Trump v. Anderson case. Because I think if I recall, there was a person running, I don't know, for some state office that was barred from, running because of the insurrection, or because of the Section 3 of the 14th Amendment. So how do cases like that and future cases, will be affected by however they rule, you think?
Yeah, it's a great question. And the effect will depend on how precisely they rule. I've seen some folks who've argued that the court will likely argue that for, again, what we call national offices, Congress needs to be the body to figure that issue out. But that for state offices, they're probably going to let state legislatures and state secretaries of state figure it out. The argument being, that's a purely state matter. States can handle that on their own. It is interesting, though, to me, because there's no reason in the language of the Constitution to suggest that there's any distinction between the two. Folks are simply disqualified. And the question of what qualifies as a disqualification is one that, in theory, should simply be decided by whomever has a responsibility for things like ballot access and issues along those lines. I mean, I'll be very interested if someone says, well, Congress should be responsible for national offices. We've already had Congress say that, I think it may have been a joint resolution. Well, actually, it may have just been a resolution of the House. I think it's just a resolution of the House that President Trump did not engage in insurrection. Okay. I mean, we have I believe a congressional committee report that essentially says, yeah, he did. So when we say Congress should be responsible for these issues, what do we mean? And what might the court mean? Does the court mean Congress is responsible for the presidential election, whatever that means, but states are responsible for state elections? Or if folks say Congress is responsible, should that mean that Congress should be responsible for even state issues? That is, should Congress's decision, for example, on whether January 6th was an insurrection or rebellion, assuming one could get an actual decision, should Congress be responsible, and should Congress's action then guide what states do? So assume that Congress gets together and says, you know what, we actually think that January 6th was an insurrection. Should states be required to take that as the truth and merely ask themselves whether a candidate, even for a state office, was involved in January 6th in a way that means that they engaged in insurrection? Or should the state be able to just decide on its own because it's talking about a pure state matter? Should they be able to decide on their own, regardless of what Congress decides, whether or not an individual can run or not? Now, we know that Congress could decide by the 2/3 vote that the disability is removed. So we do know that Congress could Bigfoot states, even if the Supreme Court said that states generally can apply 14th Amendment Section 3, but could Congress Bigfoot states without the 2/3 vote and simply say nobody who was involved in January 6, 2021 shall be deemed to have been involved in an insurrection? That's going to depend on how the Supreme Court writes the opinion, and that's going to be fascinating.
Yeah. I mean, like, do you think that if Trump had been prosecuted, and a jury found him guilty of insurrection, that would have lended more, I don't know, credence to the argument? And secondly is, so Jack Smith is currently investigating Trump's involvement with January 6th. And if he's found guilty in that, like, do you foresee this, I don't know, this case being resurrected, if that's even a thing?
Well, I think one question is how should we deal with the question of a jury? Which jury? So are we talking about a Colorado state jury? Or are we talking about a Colorado federal jury? Why should we necessarily believe that I know why I would, but why should one necessarily believe that folks would take a jury's decision seriously, particularly given how the president has now gone around trashing juries in general? It's a hard thing. Now there is there's the insurrection statute, and like you say, if one is guilty on the insurrection statute, I'd have to look at it to see whether a jury's decision alone triggers disqualification, and whether that disqualification should apply nationwide. That would be an issue, and one could see the court saying, "Boy, if we think Congress should figure this out, then Congress should figure this one out." The other piece is, what if President Trump was found not guilty after being charged with insurrection? And we know he wasn't charged with insurrection, but what if he had been charged with insurrection and was found not guilty? Well, we recognize that guilt involves proof beyond a reasonable doubt. Congressional legislation doesn't require that. So whether one would say a not guilty in an insurrection case means that we are required to treat you as though you did not engage in the behavior, that's an interesting question. As we've seen in other cases, sometimes you can be acquitted of a criminal matter, but the same matter comes up in a civil case, and folks find that in a civil case, you are liable. We saw that, of course, with the O.J. Simpson situation, right? Found not guilty of the homicides, but when he was sued for wrongful death, was found to be liable and responsible. So that issue is just I think it's a fascinating question. It would be nice if the court resolved it rather than in some ways looking for an off-ramp or ducking it. What I'd like to hear the court talk about is, why do we think that this language that clearly suggests disqualification, if one has engaged in insurrection, why that's not a straightforward command that the courts are supposed to apply it? I haven't really seen that. I've instead heard them say, functionally, we don't want to get involved. Plaintiff or Colorado, tell us why we have to get involved. And that seems like a flip of what you would normally expect when you have relatively arguably relatively clear language in the Constitution, you would think that the court would say, okay, we're going to figure out how to solve this. Now tell us why we shouldn't solve it in this way. And that just wasn't the feel. I realized that they may get to the same place at the end of the day, but that wasn't really the feeling that I got when listening to the oral argument. I guess I got the feeling they didn't want to be involved. They'd rather be somewhere else. And by God, they were going to figure out a way to be somewhere else.
Yeah. Side question. Are you familiar with any of the folks presenting the arguments?
I don't know them in any real fashion. I think they all did a fine job of presenting the case, given what the court had to say, given the questions that the court asked. I thought President Trump's lawyer, Mr. Mitchell, actually did a really good job. The thing that I think he did the best job on, and this is going to sound kind of goofy, I think he actually did the best job on rebuttal. It was a very short rebuttal, but he clearly honed in on the issues that the court was worried about, and just gave a nice sort of end of, yeah, court, you should be concerned about those issues. and in that respect, I think he did a really good job. I mean, he also certainly did a good job in the main as well, and largely went where he thought he should go. He did kind of brush off Justice Jackson, which actually I think it made sense for him to brush her off in some respects, because the argument that was being made that the fact that the president wasn't listed in the offices, the notion that the president wasn't listed meant that he wasn't covered, I just find that argument to be extraordinarily weak. And I'm sort of glad that he didn't go forth. I hope and pray that Justice Jackson does not write anything regarding that argument in the opinion, because I think that will be a problem for her record historically. The idea that the president is not included in that list of folks who cannot serve. That notion seems odd. The idea that you would disqualify all those other people but would not disqualify the president of the United States, given how the language is written, just is problematic.
Yeah,
it's very problematic.
Yeah, because and maybe you can unpack that a little bit, because from what I recall, it's like they were making the argument that, you know, people in the president's cabinet are appointed. You know, the different secretaries are considered office holders, but the president is elected. His cabinet isn't elected. So can you maybe, you know, discuss sort of the disparity between those two, and kind of like why you think the president should be considered an office holder? Sure.
So the language, I'll just read the first part of section 3. It says, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state. So take that clause. The argument that is being put forth is, well, they named senators, they named representatives, they named electors, and then they had the catch-all officers, right? Officer under the United States. In fact, it's hold any office, civil or military, under the United States. And the argument that gets made is, well, if you wanted the president to be included, you should have included the president at the beginning of that list. Should be president, senator, representative, etc. And that's what you should have done. So the fact that he's not listed is a problem. Well, the response is, well, it says hold any office, civil or military, under the United States. That includes everybody. Now, the argument that folks have made is, well, an officer under the United States, those are people who are appointed, and everybody listed before is someone who is elected. Now, it's an interesting argument there. One is, that's just not true as of 1868. U.S. senators were not elected in the way we think of them being elected in 1868. They were appointed by the state legislature. Now, that's not to say that there weren't elections, but the group that appointed them was the state legislature. So they weren't elected in the way that we think of folks being elected. By the same token, electors for president and vice president, they also, sure, they were elected in elections, but only because the state legislature said the way that we will elect our electors is through elections. Even as of today, because if you go back to 2000 and you see the Bush versus Gore decision, the court very helpfully told us that the only reason we get to elect the electors is because state legislatures say that we get to elect electors. Back in 1868, it's not the case that it necessarily was the case that the people were going to elect electors. So the idea that the folks who are listed are elected officials and the folks who are in the officer category are appointed, one, that doesn't really hold water. But here's the piece that's far more important. The folks who are listed by title are elected by states or the people of states. Senators chosen by the state legislature, which acts for the state in its capacity. U.S. representatives are elected by the people, but they're elected by people in states. Electors are elected by people in states. So as a consequence, it makes perfect sense to have that list of people, none of whom hold federal offices. Now, we can say, well, but U.S. senators hold federal office. That's not what we mean, right? Then you have all officers under the United States. Well, is the president more like the folks who are listed in the first piece, or is the president more like those folks who are listed in the second piece? I'd say the second piece, because the folks in the second piece are all people who hold office under the United States. The president does not hold office by virtue of having been elected by a single state. The president holds office by virtue of the Electoral College. So it makes no sense to list the president at the head of a list when that list is very different from the folks who hold federal office, right? The Secretary of State does not hold a federal office as the Secretary of State because they've been elected by the people. No, they hold that office because they're working for the federal government. In the same way that the president holds that office. So the idea that, well, my goodness, the president isn't listed, the president is subsumed under the notion of people who hold federal office. So that's the reason why I look at that and I say, when you start talking about, well, it's a national election, that's how people get confused as to why the president doesn't seem to be listed. The president is listed because the president is subsumed under people who functionally hold office under the United States of America. Of course, the president is included. And the argument that we should pull out the president because the president somehow is different and the vice president somehow different, no, they're not. You only get there by continuing to talk about national this, national that, and thinking that the president and senators and U.S. Congress people, well, they're the ones who are elected to federal government. That's not how it works. And frankly, that's not how folks were thinking in 1868 either, because they had just fought a civil war where states were claiming that they had the right to secede as states. So we understand that the notion was states were states and we were a union of states. Now, we were indivisible and inviolable, but we were a union of states. When you think about the U.S. as a union of states, the way that the list works makes perfect sense. And the president as an officer under the United States is just clear and obvious. And to say that it's not, you got to do some fancy dancing to say that it's not. And that's why I hope that Justice Jackson writes nothing along those lines, because I just think it's a problem to think of it in the way that she's thinking of it. And I think there's a reason why she's the only one who kept on pushing on that argument, because I think the other folks are like, yeah, you can have that one. We got plenty of other off ramps. We don't need that one. We'll take a different one. So that's kind of where I'm there. And the reason why I'm so animated about that is so much of the Constitution is written on what I call a chassis of the U.S. as a union of states, that people sometimes get away from that, except when they want to prattle on about states' rights. Then they find it. When Governor Abbott talks about Texas and what Texas has a right to, it's like, man, come on, right? So people can find it when they want to. And my deal is, let's just be consistent about it and recognize that the language of the Constitution is one that treats U.S. senators as being from a particular state, not as being truly a federal office. I know I've been talking for a bit. I'll just make one more point before before I let you in, get a word in edgewise, and that's this. When you think about Nikki Haley and you ask, well, what was Nikki Haley's job in the Trump administration? Well, she was the U.S. ambassador to the United Nations. She was our representative to the United Nations. She was not a United Nations official. She's our delegate to the United Nations. That is the mentality that actually underlies how we deal with representation to U.S. Congress. I realize that we don't think of it that way today, but in 1868 and certainly before, that's the deal. In the same way that if you look in the congressional record, people are not listed as just being John Smith. They are Senator so-and-so from state. Because we recognize that all of the people in Congress come from a particular state. We don't have any districts that cross state lines. People are chosen from states, and that's what's going on. And if you look at that language through that lens, then it makes perfect sense. So that's kind of the way I look at things. And I get on my soapbox a lot in voting rights because I tell my students, I say, look, we talk about federal elections. Please don't call them federal elections. Please call them state elections for federal office. Because that's what they are. When we elected Tim Kaine and we elected Mark Warner here in Virginia, they are our U.S. Senator from Virginia. That's what they are. We are sending them there. And while I believe that we are a nation and I believe that we are a country, the language of the Constitution doesn't speak like that. So that's something we have to deal with.
Yeah. Do you think the arguments would be different if we were talking about Vice President Trump versus President Trump?
Ironically, the same argument regarding president works for vice president as well. Now, if the notion is, well, let me ask you, do you mean we think that a vice president had engaged in insurrection possibly, or do you just mean the office of vice president?
Yeah, that the vice president, because it's not, the vice president isn't like a role that we elect, right? It's chosen.
Well, yes and no. The Electoral College does select the vice president separate from the president. It's just that they essentially run on a ticket. But in theory, one could, in places where you're allowed to be a faithless elector, you could decide to vote for someone as vice president who was not running with the president themselves. So the structure, that's how the structure works. Now, practically, it doesn't really work that way, but technically, we do elect the vice president. But like I say, it's the president and vice president are yoked usually, and as a consequence, because they're yoked, we think of them as being elected the same way. And certainly, the president selects their own vice president. Some folks will argue, why does the president select their own their vice president? Why wouldn't the party? Right? Because really, the presidential candidates typically are running as representatives of a party.
Yep.
It's actually not clear to me why we would want the president, the presidential candidate, at the convention to be the one who selects the vice president. Mm-hmm. In theory, we probably ought to say, well, look, if the Republican Party wants X as president, then maybe the Republican Party should be the one that chooses Y as vice president. Mm-hmm. And the notion is, if you're running on our ticket, if you're running as our nominee, then we should be the ones who decide who the vice president, who the vice presidential candidate is. That's not how it has worked. But I think that arguably would make a lot more sense considering what's actually occurring, right? In terms of President Trump in 2016 was the Republican Party's nominee for president, and Mike Pence was the Republican Party's nominee for vice president. Interesting in terms of if we changed the way we think about that. How we might think about the vice president's position. Yeah. But no, you raise a good question. I think that the language of the Constitution treats the president and vice president the same for Article 14. For 14th Amendment, Section 3 purposes, in part because it doesn't list either the president or vice president. So in theory, they should be treated exactly the same way. Now, there's a slight difference in terms of when folks start talking about, well, what oath did the president take versus what oath did the vice president take? Mm-hmm. But I also find that to be a pretty weak argument. The idea that the president takes an oath to preserve, protect, and defend the Constitution, and everybody else takes an oath to simply support the Constitution, and therefore his oath is different, therefore it's not covered. That strikes me as being pretty weak sauce. Yeah. It's clear that they're talking about people who had taken an oath regarding the Constitution, and that includes people who took an oath to support it or the oath that the president took to preserve, protect, and defend it. Frankly, preserving, protecting, and defending goes even farther than supporting it. So, but yeah, vice president and president, I think, should probably be treated the same. For the reasons that you note, they're essentially yoked together.
Got it. So Steve Vladeck, who looks at Supreme Court cases quite a bit, he posted on the website formerly known as Twitter that he thought it was going to be like a 7-2 or 9-0, kind of in favor of the president. I'd love to get your predictions on how you think that the court's going to rule.
Gosh, I would suspect that's probably right. Now, part of it depends on what we mean by 7-2, 9-0. That is, I could easily see 9 justices saying Colorado cannot take President Trump off of its ballot. I would be a little surprised if they all came to the same conclusion as to why and what the proper remedy is. And here's one of the reasons why is the suggestion has been made that given the court's position, it seems like what the court is angling for is a decision on January the 6th, 2025, by Congress regarding whether the president has been disqualified by the 14th Amendment or not. I would be surprised if there's a 9-0 decision in favor of that being the way we figure this thing out. But I have no problem with saying all 9 justices will find an off-ramp to guarantee that Colorado can't remove a president a presidential candidate on its own. That I could see them saying. I'd be surprised. The possible 9-0 agreement might be if they said, well, the fact that Congress could remove a disability between Election Day and Inauguration Day means that you have to be allowed to run for president, even if at the time you're running, you technically are disqualified from the office. Because if Congress can remove the disability between Election Day and Inauguration Day, then you might theoretically be able to serve. And if you might theoretically be able to serve, then we can't stop you from running. Maybe it's 9-0 there and the court stops there. But of course, if the court stops there, ooh, baby, it does look like there's going to be a lot of pressure between Election Day and Inauguration Day if President Trump actually won. That is it. One, you'd have to sort of have Congress determine that he couldn't serve. Then after determining that he couldn't serve, they'd have to remove the disability. What's more likely? Well, what may be more likely is folks say, fine. They throw their hands up. You can see Democrats throwing their hands up and saying, fine. If he won, we're just not going to stand in the way of him taking office. And we're never going to have a true adjudication regarding whether we won't have an adjudication in addition to Colorado's regarding whether President Trump was engaged in insurrection or not. That's possible. The functional result of that would be that the 14th Amendment, Section 3, is there merely as a suggestion to voters that they not elect someone who's been involved in rebellion or insurrection, rather than a legal command that that person doesn't qualify. And that would be quite interesting. Because there's something to the notion that that's really what should occur. That is, the people should look up and say, if we think you engaged in insurrection or rebellion against the United States, then you should not be put back into office. We've treated that as being kind of a legal thing, but if the court says we are not going to raise a finger to enforce that, then essentially it turns largely into a political question, unless Congress gets explicit about what qualifies as an insurrection. It's a fascinating result. Could be a fascinating result.
Yeah, if they rule like that, I guess what happens to the Colorado Supreme Court's, opinion that Trump did engage in an insurrection? Like, does that still stay like on the books or whatever? Like how does that sort of fit in?
I think it fades away. Because the notion would be that regarding presidential candidates, you can't keep them off the ballot. And if the notion is that you can't keep them off the ballot because they might be sworn in later, then I think functionally it means that the place where folks figure out what one should do with a candidate who may have won the election, but who technically is not qualified to serve, is the venue just becomes Congress as the place where they figure it out. So folks in Congress may say, well, we refer to what Colorado did, but frankly, Congress can refer to what its own committees reported. But the notion that Colorado would have the right to make a determination is the thing that goes by the by. They wouldn't have the right to make that determination on their own. That's why when Justice Kagan said, well, aren't you essentially asking that a single state have the right to determine the presidency? Which I got a lot of respect for Justice Kagan, but that struck me as being an odd thing to say, given that she was alive in 2020. And I realize that the situation is slightly different, but the idea that one state and their determination regarding who won the election would determine who in fact won the election, well, that's what just happened as a matter of fact in 2020. Regardless of how people come out in terms of which way one should have gone on that one, Florida made that determination, and some of the determinations that the government of Florida made regarding who won the election in Florida determined who won the presidency. So the idea that one state can make that difference, like, well, yes, Justice Kagan, that's what the Constitution says. When we add up the electoral votes, one state's electoral votes, one flip might well change the result. That's not a shocking thing. And more importantly, the way that one state counts its votes. So it's not just that, a state's results could change. It's the way that a state counts its votes might determine who wins the election in that state, and that might determine who wins the presidency. So yes, the idea that, oh my goodness, one state could have, yeah, no kidding. In the same way that different states have different requirements for getting onto the ballot. That is, different states allow some, for example, independents. Mm-hmm. Independents have to get themselves on each state's ballot on their own. They can't just show up on a ballot because they are the nominee of a major party. So for independents, some of them will be on some ballots and some will be on other ballots. And while I recognize an independent has never come close to winning the presidency, the idea that a state's rules regarding who can be on their ballot might determine who wins the presidency, yeah, no kidding. That's what happens when you run 51 separate elections and amalgamate the results to determine who wins the presidency. That's just the way life goes because the Constitution is written that way. So I found that to be an interesting way for her to put it. I get her point. Her point is, I don't want to be involved in this. But the way she put it was one where you say, that's interesting that you would put it in that way. So a lot of real interesting stuff going on here. But I think President Trump will be on the ballot. I just don't see any appetite from the Supreme Court to allow an individual state to keep him off of their state's ballot. Yeah, I just don't see that.
And then if they rule that way, does that mean like the situation in Maine, does that go away also?
I believe so. Yeah, because whether it's done directly by the state Secretary of State or whether it's done through a trial or what have you, I think it all goes away. If the court says, yeah, no individual state can do this, then I think that's how it has to work for Maine. The likelihood that you're going to get any kind of legislation out of Congress is zero. So I don't think there'll be any congressional movement on this issue. Clearly, one's not going to bring insurrection charges against President Trump between now and the election. So I think what we're going to have is a situation that some would view as being the worst of all possible worlds. That is a presidential candidate who many people believe was involved, regardless of how you get there, many people believe was involved in an insurrection. So many people believe that he's not able to serve, that he's been disqualified by the Constitution from serving, but he's going to be allowed to run and be the nominee of a major party candidate. Be the nominee of a major party. Okay, that would seem to be the worst of all possible worlds, which is why I think Colorado Republicans said, figure out whether this guy's going to be on the ballot or not. Because I can understand them being afraid and saying, well, hold on a second. The last thing we want is for a flawed candidate who many people may vote against because they think he can't serve. That's not who I want the nominee to be, and I don't want him to be on the ballot. So figure out whether he's on or off. Those Republicans might have been happy for Colorado to say, yes, he's on. But at least they wanted a decision regarding, is he on or is he not on? Because you don't want a candidate whom some may believe has been mortally wounded. Well, their candidacy, not the candidate, but the candidacy has been mortally wounded by the fact that you do have some people who are arguing, well, look, a state court determined that this guy is not eligible to serve, so I probably should vote for somebody else. I understand why one would want their candidate to be, their nominee to be as clean as possible. So this might be the worst of all possible worlds, and I guarantee you the Supreme Court is hoping, after they take their off-ramp, I guarantee you they're hoping that he does not prevail. Because if anyone's going to get blamed for leaving it until January 6, 2025, it's hard not to blame the Supreme Court for this one. Unless they give us an opinion that explains precisely how things should work, maybe they pick it up and just throw it into Congress's lap. That's possible. But I'm not sure that that's going to work. I'm not sure that saying in February or early March, hey, Congress, you get this hot potato, when the Constitution says what it says, I'm not sure that that's going to work if President Trump happens to win re-election in late 2024.
Got it. So my last question is more about like the deliberation process of like the justices. So, we all heard the oral argument. We develop opinions about it. And for most of us, like lay humans, like that's all we know. But like, will they make decisions based on, just discussions amongst themselves, or do they only have to rely on the oral arguments that we all heard?
They'll talk. And there may be a ton of talk going on, because you have some opinions that are issued as the opinion of ex-justice, and other justices have signed on, so it's the opinion of the court, but written by a particular justice. You have other opinions that are called per curiam opinions, which are not allocated to a particular judge. So it's the court saying, we as a court are issuing this opinion. And I suspect there may be a lot of talk, because chances are they'd really prefer to issue a 9-0 per curiam opinion with no concurrences and no dissents. That's what I'm sure that's what they would prefer on this issue. The question is, can you find a rationale that all 9 are willing to sign on to say we are unanimous in our decision that this is the way the Constitution applies? That will likely take a lot of discussion. So that, I think, will be a piece. Now, like I say, you can have a per curiam opinion that also has dissents involved, but I suspect that they would prefer that there be no concurrences and no dissents. So, I imagine they may be talking daily about this issue, because this might be, for right now, this is either the most important or the second most important thing they've got to figure out. The immunity piece is the other one that they've got to figure out.
When should we expect that they produce something?
I don't know. I suspect sooner rather than later. I would like to think that they are not going to hold the decision until after a couple more primaries, in order to see whether they can dodge this by. I mean, if Nikki Haley were to win the nomination, then issue resolved. At least in theory, issue resolved. I'd like to think that they're not going to hold that, but it may well be that just writing it and getting to consensus may take some time. I would like to think that it'd be sooner rather than later, because it would be nice for this particular issue to be essentially put to bed. But it could take a little while, or it might take, by a little while, I'm thinking weeks, maybe not months. I'd be shocked if it took us months. Although some might argue, who cares? That is, who cares until you get past the primary, or at least past the time when President Trump wins the primary battle, assuming he does. Because this really has to do with the general election. It doesn't really have to do with primaries anymore, because Colorado's already printed their ballots, and the lion's share of states are really up against printing their ballots. So And I don't think that there's enough stuff going on in those other states for them to take his name off the primary ballot. So I think what we're really talking about is the general. So they could take some more time for the general, but I suspect that they won't. I suspect that they will make their decision so that people will have played out what's likely going to happen, and as a consequence, will go into the general election campaign knowing that President Trump's going to be on the ballot and President Biden's going to be on the ballot, and they can just fight it out during the summer.
Awesome. Well, Professor Chambers, thanks again for letting me tap into your smarts and your brain. I feel much more informed, maybe not necessarily all that more relieved. But yeah, really appreciate your input, insight, and and to our faithful politics listeners and viewers, we'll see you next week. Take care.